Legally Speaking with me, Tarun Nangia. Now you're back to your favorite series, which you all know is titled Saturdays with Singhvi, on a very, very special subject, which is Justice Sanjiv Khanna as Chief Justice of India, opportunities and suggestions. And we have, as you all know, Justice Dr. Abhishek Manu Singhvi as our guest. For those who already don't know, he's recently won the Rajya Sabha elections for the fourth time, which makes him a senior and an elder member in the Rajya Sabha. He's been there, I think, now for close to 22 years. And of course, formerly he served as the Additional Solicitor General of India. Also, we also know now he's also heading the legal cell for the Congress party, is also part of the apex decision making of the Congress party, which is the CWC, which is titled the Congress Working Committee. So today we'll get inputs from him. Of course, you all know that in India, he's a leading lawyer at the Supreme Court of India. Any top commercial case, constitutional case, and most recently, all the top bails involving Enforcement Directorate, you saw him appearing, from Arvind Kejriwal to Manish Sisodia to many top corporates, saw his presence. And of course, that will also be briefly brought up on today's show. But good to see you again, and looking for a very interesting half an hour discussion on Saturdays with Singhvi.
Thank you so much, Tarun, and not so much thank you for making me feel so old and elderly.
But interestingly, Justice Khanna, 6 months tenure, 51st Chief Justice of India. And of course, you've seen him from a long, long time in the city of Delhi. Could you speak about the man and the judge, Justice Sanjiv Khanna?
Well, I also, like many of us, started my career in the Delhi High Court. So I consider myself, in that sense, a Delhi High Court wala. Proud that he's from my High Court, if you were to call it a parent High Court, because there's no other High Court I've really started from. Chief Justice Khanna is, first of all, a very nice human being. He's innately nice. He's a very gentlemanly person. And he is a non-confrontationist person, from what I have seen of him for all these decades. I therefore expect change with continuity and continuity with change, which is possibly the way it should be also. For those administrative, managerial issues, I would call him a team player, a team worker. Not necessarily, on the other hand, on the judicial side. He has a very independent mind. You must remember that he's one of the few who's actually practiced at some length in the district court before he went on to the High Court. He's also a nitty-gritty judge, a judge who loves to grapple with the details, the minutiae. And as we say, as I always say in a lighter vein, both God and devil in different forms lie in the detail. You have to see him contextually. He has been a standing counsel for the Income Tax Department for decades. He has been a standing counsel for the NCT. So therefore, he has a certain worldview. That worldview can even be called, no doubt, that he's conservative. No doubt that he is very concerned about protecting the revenues, where he feels that there has been a diminution or a potential loss. But what I really would laud and admire and endorse is that A, he has outgrown those isms of those long years of practice. And B, the moment he is convinced, he is absolutely unhesitating, fearless. If you convey it to his mind and it gets into his mind, then I don't think he hesitates in any manner, be it a government matter, revenue matter, liberty matter. And I don't think consequences after that conviction matter to him at all. So overall, in a nutshell, expect a 6 months of continuity with change, attempts to reform. And by the way, as we speak today, we have what we had heard last week, an announced reform for example, that's a good thing, a very good thing. NMDs, what lawyers call NMDs, non-miscellaneous day matters, which is basically limited to Tuesdays till now, are semi-long matters, longer than miscellaneous short matters where you issue a notice of a stay, and shorter than the so-called regulars. So now the NMDs will cover and span the whole of Tuesday to Thursday. I think the idea is not to give regulars a backseat, but the idea is, and this is the right way, a judge who knows that he has 6 months should not try and cure or reform everything. He should pick and choose, and he should choose in particular those areas where he can be seen and evaluated to have left a mark. Now, clearly, if under Chief Justice Khanna's stewardship, the court disposes of the hundreds, possibly thousands of NMDs scattered along the various courtrooms by having from now at least till 20th December when our recess takes place, only NMDs on not only one day Tuesday, but Tuesday, Wednesday, and Thursday, he would have left a mark in that he would have diminished from X to 0 or X to very, very close to 0 the bunch of pending NMD cases. And I think that's the right way to go.
Point very well taken. Moving ahead, if you could come up with a couple of suggestions that what he could do in the next couple of months. In the recent past, we saw him giving a lot of orders, judgments, which gave priority to personal liberty. And in some of the high profile ones, you argued before him and those orders were given. So, in a sense, he's a very staunch supporter or a votary of personal liberty. But Supreme Court has all kinds of matters. There are big infrastructure cases, cases with high stakes involved. What would you suggest to him? What can be done in these 6 months? Because 6 months is not that long a time, but not also not that short a time. In your view, what can he do in these 6 months?
Tarun, 6 months and minus a few days because of various holidays, you must pick and choose. And you must pick and choose wisely, carefully, with two tests in mind. One, what you do in those picking and choosings will leave a mark that, look, Tarun Nangia has done it and closed it. Chief Justice Khanna has done it and closed it. And two, it should be of relevance and immediacy and weight and urgency. From that point of view, there are a lot of things you can do. Of course, I mean, each person will have a different wish list. I'm not going to give you the more procedural or the more managerial or the more advocate and record oriented wish list. I have them myself, but I mean, no point giving because you will already have them from people who are specially practicing with that focus. But one thing could be that, courts get a bad name by saying, look, the earliest case pending in the Supreme Court is 2000. I'm giving an example. Or the earliest case pending in the Supreme Court is 30 years old, 1995. I'm giving only an example. So there is no reason why after this first 6 weeks, which he has devoted to NMDs, he does a similar kind of experiment with plucking out two categories, subcategories. One is a period. So let us say he picks out the oldest 5-year cases. I don't know the year, but whatever. And if there are too many, then he plucks out a subcategory of them. A subcategory could be a matter of choice. It could be something, I'm giving again examples, something as important and yet not so important as 138s, which are clogging the court system. That is the bouncing of check Negotiable Instruments Act cases. It could be the so-called dowry deaths 498 cases, which are also in another sense clogging the lower courts. It could be a third category, but all of the within the old category. So suppose there's a 30-year case, then he can take all the 30 to 25-year cases. I am sure if he focuses like that, he'll leave a mark where he'll be able to say that, look, the entire backlog of A, NMDs of Supreme Court, and B, cases of the oldest will go. Thirdly, he should consider in the process of doing this, track 1, track 2, and track 3 courts. There is no reason why a track 1 or a track 3 court will take up only a particular category of cases with the tasked object of just finishing them off, maybe in 2 months. The smart judges who can sit down and take it up. The people who may have expertise in that subject. The people who have the willingness and the readiness to do it. That is all man management, person management. and you task them that, look, I'm giving you a category of cases that should be completely off. And these are things which are doable. I'm giving you the doable items. I can give you mega plans of grand plans, but it won't happen during his time. So therefore, it's better for him to take up these things. Of course, there's all the usual irritants of infrastructure he should attend to, which all of us have wish lists. But I think he's also a person who believes very much in the fact that the role of a judge is to judge. So I don't think he's going to be too much into other extracurricular activities. He's going to focus on judging, and this will fit him well in this particular category of cases. You mentioned liberty. As I said in one of your earlier programs, the PMLA, perhaps not designed as a fortress, was made into a fortress by a overwhelmingly servile approach to it in the initial years by courts who saw it as a formidable, impenetrable fortress with moats and cannons all around. That got exacerbated by a deferential attitude by lower courts. What has now happened is that each wall of this so-called fortress has fallen already. Many parts of its roof are leaking. Its windows are going, and soon you will find it to be much less fearsome, much less capable of misuse as it has been till now, because one by one, the important principles of law have been plugged and clarified. And in that, a major role has been played by Chief Justice now, but then not Chief Justice Khanna. And as I said, he's conservative. He's slow to be convinced, but once he is convinced, he doesn't hesitate. So reason to believe, necessity to arrest, urgency to arrest, the review. He's identified these issues. Some he has decided, some he has not. But in the process, he has made the PMLA what it should be, not a virtual anti-terror legislation, not a virtual political tool for misuse. And some of the matters which we have done, and I've had the privilege of doing many of those major matters, have been truly path-breaking. And he has taken that, he has walked the talk.
Point very well taken. I want to ask you this particularly. There are curative cases in the Supreme Court. Then there are some important cases like the review in the case of Vijay Madan Lal Chaudhary that will have a far-reaching impact on the adjudication process in terms of those laws, the PMLA, and of course curatives. Many times these days are also seeing a lot of commercial cases that go into curative. Do you think it's better to dispose of these categories of cases as soon as possible, given the important issues involved in terms of
Absolutely, Tarun. When I talked about my example that you choose cases the oldest, you can have a track 3 bench for, let us say, a month or 2 months, taking up, again, it's a matter of choice, whatever are the most important infrastructure cases, or whatever are the most important similar kinds of cases holding up projects, and deal with them one way or the other. That requires minute screening and identification and a dedicated bench dealing with it. Not too long, but yes, a few months. And then they just hear it Monday to Friday, and adjournments are minimized, and you just deal with it. Also, don't forget, he will have time to make a few appointments. Personally, I expect the Delhi High Court is likely to get a representation very soon, even this month. He's a man from Delhi High Court. He understands that court. And he has a few more retirements coming next year during his term. So he will be doing that. He will be having to take his colleagues with him. And I think in shorter terms, which are this term and the next person's term, Justice Gawai's, it is best if they, coordinate as much as possible so that they actually can count it as 1 year rather than 2 6-month terms. Handing on the baton, I proposed long ago, many, many years ago to many Chief Justices that really speaking, you can't have 5-year plans, but there's no reason why the Supreme Court of India should not have a 3-year plan for all the Chief Justices over the next 3 years. And they can agree to disagree on any number of other issues, but they can say, look, the common minimum program of these Chief Justices who fall in the next 3 years is 1, 2, 3, 4, 5, 6. That will give a tremendous momentum, push, and synergy. And there are a lot of things on which you can agree. There are a lot of things you can't. Leave those aside. A lot of things you can agree. And there is no reason why people with 6-7 month tenure, the next person with 6 months, another person with longer, should not be able to sit and do it. But of course, these are human interpersonal relations. They require a certain, handling. So that's another area he should look at. But old pending cases, categorization, subcategorization, and the appointments will, I think, judicial appointments will, I think, keep his plate full.
In fact, when you said appointments, I want to do a follow-up question. All commercial cases land up at the Delhi High Court because parties choose Delhi as a jurisdiction to settle their disputes. Recently, we did a show calling for 90 judges at the Delhi High Court. Currently, we are at 37 out of a capacity of 65, the sanction strength. We said no, increase the sanction strength. The pendency of cases is 1,25,000. It will take 10 years to dispose even the current cases. Do you think in this area, Justice Khanna could do something by greatly ramping up the strength in Delhi High Court from 37 to 50 or 60 or 65?
I understand the angst in your question, Tarun, but we have to be understanding the nuance of it also. My classic standing joke for many years has been that, I don't know which year, about 10, 15 years ago, the strength of all high courts was increased across the country. It was increased by 1.5 times, sometimes 2 times. 1.5 definitely. My classic joke was that for years, close to decades after that increase of sanction strength, 90% of those high courts are functioning below the original, unincreased, sanctioned original strength for a decade. So my first point to you is that it's easy to show this alacrity in increasing on paper. What's the use of increasing on paper? Your own example is the best example against it. Delhi High Court already has 60. अरे भाई आप बढ़ाइए जरूर, लेकिन 60 तो पहले भरिए. आप अभी में 90 बना देंगे, आप 60 भरने में असमर्थ हैं, तो आप 90 कैसे भरेंगे? Therefore, the point I'm making is first go and show that you are near full capacity of the sanction strength in every high court. And then, otherwise, you go to the government, this requires a government approval for various things. You can't just increase it like that. The first question will be that, look, where is the question of increase? You're not even able to appoint the sanction. And then, of course, the second problem here in this kind of a question is, Tarun, that, it's easy to, assuming you increase and assuming you appoint, which are two big assumptions, by the way. They're not natural assumptions. They're not naturally going to happen. It's not a mere numbers. We tend to forget, these numbers may be possible because indiscriminately I need to desperately fill up these numbers. It's the quality which matters. A judge who is of indifferent quality will block that seat for decades. He will actually increase areas, not decrease. He will actually lead to all other kinds of insinuations and innuendos against the bench. So you have to balance. And as I always say in my other slightly, lighter vein, but not entirely lighter, serious vein also, that we again have the second unique knack of finding the best 5 or the best 10 in every high court to appoint. And then we find ways of disappointing them. So, you need to get your appointment disappointment ratios correct. These are the realities of India. India is not a place which lacks principle, law, regulation, structure, model. What it lacks is operational reality. Operational reality is very different from the grand models we have.
One thing I want to ask you, sorry to interrupt you, but I couldn't help asking this to you. I have seen the kind of complex cases you argue in court day in and day out. Sometimes in infrastructure disputes, there are so many thousands of documents, calculations. When choosing a judge, and now you're only talking of commercial cases, and given the complexities of commerce, do you think selection has become a much tougher job? And that is the challenge for Justice Khanna, picking some bright young lawyers as judges who can then, understand the complexity of the disputes that we are going to face in future.
Absolutely. And it is not a question of only, of course, it is a matter of commercial. When we started practice, we used to say IPR, IPR, IPR. IPR meant basically trademark and a few copyright cases. Now, when you say IPR, you hardly get these two categories, especially copyright. You mainly get patents. Now, patent requires a certain different approach. Arbitrations require a certain expertise. So certainly, I do not believe in specialist judges. I do not believe in specialists. Experts are not the point I'm making. But you need bright, analytical, adaptable, hardworking people who can come to grips soon. And that a person will do howsoever a generalist is, if he's willing to work hard and apply himself. So that is absolutely correct what you're saying. But along with that, after I appoint you, I assume that I appoint you after I find you to be suitable in all the respects in which we are talking. After I appoint you, it is then again also the job of that Chief Justice who's presiding in your court to ensure that you get the right work.
Yes.
I mean, I go and put you in a roster which has no connection, no interest, and maybe is something which you have never even touched or seen in your life. Then of course it's a misuse of and that also happens sometimes. So these are things which are realities, but these are also things which we all understand. And no better than Justice Khanna to understand all this. He's seen all this in the nitty-gritty of Delhi High Court and the Supreme Court.
One thing is alternative dispute resolution. Arbitral awards of 2009 and 10 are adjudicated in Supreme Court in 2024. This has an impact on investment in India because promoters and investors get scared. What can he do, Justice Sanjiv Khanna is Chief Justice of India, on the issue of arbitral appeals that land up in Supreme Court, that the awards pertaining to 2009, 10, 11, 12, clearly, the interest costs have shot through the roof.
So the same answer I gave you earlier will apply to both this and the question you raised about curative, which I forgot to address. In the categorization which he can do in this 6 months, for the 2 months he puts 2 rosters or 2 benches on this track, he can easily select some category like this. He can say all arbitration matters where the award is on or before a certain date. I'm giving examples, but what you say can exactly be done, because the same thing can be done about curatives. Now take curatives for instance. Curatives actually should and do make news only when they're allowed, because that should be a rarity. The idea of curative has to remain a rarity. Now we've had a few recent cases of high profile which have created ripples and waves, but normally it should not take time to list all the curatives and deal with them. And many of the curatives, could be decided with the stroke of a pen within the next few weeks. It's a question of following up on them. Yes, the very few, the rare few, which deserve a greater hearing and possibly an allowing of the patent should also be put down quickly. The whole point is that the method I've suggested of 2 or 3 tracks is subject neutral. You choose the subject you think important. Certainly what you're saying is important: infrastructure, arbitration, curative, commercial matters of a particular kind, which are projects held up. But then you put them in that track. And you're not keeping that judge bored or stuck for years on that. You're putting him on a track for 2 months. If you're not 100%, he'll dispose of 50%. And imagine the synergy of a Monday to Friday track for, let us say, your curative example, or let us say you're not curative, but let's say arbitration example. Monday to Friday, within 1 or 2 days, adjournments will stop. People will know that they're coming. 5 days attacking one particular subject will make a lot of difference. It'll clean up. We are doing it for the simpler ones. We do this 5 or 10 bail matters and transfer matters every day. We still have a backlog. But that process is disposed of hundreds of thousands. There's no reason why we can't do it for the regular basis. At least spare, once you appoint the 2 or 3 vacancies we have, and you have 35 people, spare 2 benches for this kind of work.
One thing I would like to ask you here is that you have appeared in a great many constitutional matters related to formation of governments in the states. Recently, we saw that even the Chief Justice of India was dragged into a discussion, in a political discussion during elections, which I don't think used to happen. We've not seen it happening in at least in the past 15, 20 years. Do you think the political class gets frustrated when important political matters are not adjudicated within a time frame? What can Chief Justice of India, Justice Khanna, do so that these matters related to formation of governments or related to MLAs, speakers, qualification, disqualification, can anything be done on this, or do you think that difficult to
let me tell you, Tarun. I don't go by the static of political discourse, although don't forget I also straddle public life as much as law. But I don't get overawed or go by the static, the noise, the cacophony of that. Equally, I agree with you that discourses have changed and people talk here and there, and some of that what they talk is nonsense. But There are a few narrow category of cases. Complainants and irritants will always be there. Everybody who loses or doesn't get relief will be complaining. You should ignore those category of people. But there are always a category of cases which are unnecessarily kept languishing, bringing a certain pressure and provoking such kind of comments you are saying, which may be justifiable. I'll give you an example. I have been on record, and just today, in fact, a very interesting article has come, authored by me, where I have said publicly that the Chief Justice who has just emitted office has been outstanding and deserves kudos and deserves praise and approbation and not denigration. And he has faced some flack for issues which I think fall in an error of judgment zone of 5 to 10%. He has made errors of judgment, but that is 5 to 10%, which you cannot lead to ignoring spectacular achievements in 90%. I've said so publicly in writing, I'm saying so again. But I'm answering a question. In that 5-7%, I have also equally faulted him for not being able to take up the two cases, and not because I'm appearing in them, but because in those cases, in fact, it was his initiative by giving repeatedly repetitive short orders and directions to the Speaker of Maharashtra that we got an order, because the Maharashtra Speaker, according to our side, was delaying matters. So the Chief Justice, the then Chief Justice's bench, passed not one but 3 orders, saying you decide in 15 days, 20 days, etc., etc. And ultimately decided. Now, having decided, that matter has been shown on the list always. And for that not to be taken up sounds inexplicable. That is what leads to this angst. Of course, now part of it may have lost its relevance for the next 5 years, because now the elections are over virtually. Part of it may be argued to be infructuous. I don't know. I'm not getting into all that. But
My limited
a certain amount of criticism which could have been avoided. It doesn't mean that because I'm a political case, Tarun Nangia must pack up shop and start hearing me first. I don't agree with that. A lot of people misuse it. But there are some issues which require a timely healing touch this way or that way.
My limited point was only because, allow me to give this input. For the first time in the election campaign, the names of judges were taken, which was unprecedented. We never saw this in this country before.
I would not endorse that or support that at all. But, I'm also saying that in those rare 1 or 2 or 3 category of cases, you should not give the opportunity of those names to be taken if you have a timely approach.
Okay. You made a fair point. Yes. I mean, this could have been avoided, is what you said. My final question to you today will be that your wishes for Justice Khanna. What is your wish to him for the next 6 months? What do you wish for him? Because,
Well,
I'm asking you because it's at the pinnacle of his career. He will enter maybe the arbitration career, but I think he's peaked. I mean, he's one of the few lucky ones, also fortunate ones, to become the Chief Justice of India, the 51st Chief Justice of India. Any good wishes for him?
I see, first of all, I think it's supposed to be cherished. It's the acme and the conclusion of a long, illustrious career. And everybody, after all, at the end of a long legal career, can only aspire to the topmost post in that subject. And that certainly for a lawyer and a judge is the Chief Justice of India. So it's something which both he considers a great honor and is a great, remarkable honor. And I think he's an absolutely fit person to discharge that honor, which the country has bestowed upon him. Secondly, my wish would be that he would take up just 3 or 4 of the points I've made and deal with them and leave a lasting mark by closing them, rather than take up a plateful which he cannot handle, digest, or eat, because there's just too many things which are available. So while issues A, B, C may be important, nobody's saying they're not important. If you cannot do them in a finite short time period, you will have no concrete benchmark left. Whereas issues X, Y, and Z are doable. And the examples I gave for that was 1, taking up a batch of the oldest cases, 2, taking up 4 subjects, 2 subjects, 3 subjects, and putting them on 1 or 2 bench tracks to do Monday to Friday and finish it off. It would have a huge impact if you were to do that, let us say, for all the projects above so many thousand crores. If you do it for all arbitration matters where the award is more than 10 years old. I'm giving just examples again. This can be tweaked, but the concept is valid. And so on. So this is my wish list for him. And of course, always that, you have to keep your sanity amid so many files being thrown at you, amid so much workload, and you have to be able to balance both a work-life jugglery and also the pressures of court. So my wishes, of course, for that as well.
Thank you. Thank you so much for talking on Justice Sanjiv Khanna on this episode of Saturdays with Singhvi. I know we'll see you arguing in his court. Every word of what you say will be reported. Every comment of his will be reported, given he is the Chief Justice of India. So that banter in court we all want to witness in the next week. So report on it, cover it, do shows on it. Looking forward to very interesting next 6 months. And of course, we will cover that on Saturdays with Singhvi too. I'm sure you'll give us ample opportunity to do a couple of shows in the coming months on the arguments that you did, and of course, judgments. Looking forward for him. Thank you so much. You're saying something.
Thank you so much. Thank you so much. And thank you for all the kind words. And yes, we certainly look forward to interesting developments. Thank you.
Thank you. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.